Good evening, and welcome to this hearing this evening. The purpose of this session is to hold a public hearing concerning Bill number 2017-06, also known as Zoning Text Amendment number 16-144, and Subdivision Regulation Amendment number 16-02. Tonight, as it is with all of our public hearings, it's the Commissioner's opportunity to receive comments from the public on the matter before us. We will not be entertaining questions or debating any of the issues tonight. We are really here to listen to you and get your thoughts on the matter before us. As always, your statements are limited to 3 minutes or less. I will remind you at about 2.5 minutes to please summarize. It's the same for all speakers, and that we would ask that you would respect that. So when it is your time to speak, Madam Clerk will be calling you up and asking you to please state your name and your address clearly for the record. The Commissioners reserve the right to extend the time frame tonight or to continue the hearing until a future date. So with that, if it pleases the Commissioners, I'd like to dispense with the reading of the public notices. Thank you. It's a good thing because I never have them up here anyway. If someone didn't let me do it once, we'd be in trouble. So with that, I think the best way to start this off is that we'll have a brief presentation of the proposed legislation, and then we'll follow with public testimony.
Commissioners, yes. If I could just make a brief comment. We have some technical issues, and so it's Ms. Weaver is going to give her briefing from her seat. Okay. You're not able to actually follow along as you typically would when you hit the switch button to move into the other monitor. So if you please follow along from your board docs presentation.
Okay. So there is an advantage to having a hard copy.
There's always that.
Thank you very much. Would you like an extra one up here if anybody would like?
Good evening, Commissioners.
Good evening.
Ladies and gentlemen of the public, present and watching on television. I'm just going to give a brief overview of the proposed legislation, and then I will turn it over for public comments.
Thank you.
Okay? And again, it is on board docs if you have your board docs available. Okay, so moving to the first slide. The purpose of the proposed legislation is to specify that appeals from the Planning Commission will that the appeals from the Planning Commission will go to the Board of Appeals. In addition, the Board of Appeals may not hear appeals from the decisions from the County Commissioners. It clarifies on Section 297-411 that those changes are applicable only to the hearings that deal with exceptions, variances, or non-conforming situations. And basically those issues that the Board of Appeals hears as a matter of first instance and not as an appeal. Section 297-417 deals with the process for hearings on appeals, and then also establishes a standard of review for the appeals before the Board of Appeals. Going to the next slide. County Code Section 278-106 is where you will find the language that specifies that appeal from the Planning Commission must be appealed to the Board of Appeals. County Code Section 297-409 is where the language is found, which states that the Board of Appeals may not hear an appeal from a decision of the County Commissioners. County Code Section 297-411. This is actually the section that deals with the time frames for providing notice to the public of a public hearing. And that's been amended just to specify that those sections apply to hearings on applications, special exceptions, variances, or non-conforming situations. How the appeal hearings will occur as for an appeal before the Board of Appeals, that's the handle in 297-417. As for the changes in 297-412, I just want to say from the outset, there is no intent from this legislation to make so that appeals before the Board of Appeals are closed meetings. I know there's been some comments to that effect, and that's not the intent of this legislation. All of the hearings for the Board of Appeals, because they are a public body, are open meetings, unless for some reason they close it pursuant to the closed meeting section of the Open Meetings Act. So there's no intent to make appeals closed meetings. 297 is basically, and the changes are only in paragraphs B and E, and those changes are basically just saying that they apply to hearings of special exceptions, variances, and nonconforming situations. Again, the process or the method of holding hearings for appeals is mostly defined in 297-417. So just making clear that in this section, and it's only paragraphs B and E, that those the dictates in those paragraphs apply just to the hearings on special exceptions, non-conforming situations, and variances, which again, the type of hearings the Board of Appeals hears as a matter of first instance. It's not an appeal for them. They're hearing the application. Okay, County Code Section 297-417. Again, it starts by saying that except for the decisions from the county commissioners, because of the prior section I referred to, the Board of Appeals is not hearing appeals from the county commissioners. But as far as the other appeals that the Board of Appeals has the power to hear, a person can file an appeal if they're aggrieved by the decision and if they were prior to the decision being appealed, or if they're an officer or unit of the jurisdiction affected by the decision. Now, because with that language, because of the changes that's been made by the Planning Commission to its rules of procedure, as well as the County Commissioner's recent adoption of Bill 2017-02, which basically is a concept plan, and that bill basically allows more public comment at an earlier stage in the process. So basically, it's opening the door for more people to file an appeal for the Board of Appeals, and I think it's going to limit a lot of the litigation the county has had as far as, do you have a right to file an appeal? Because basically, under current case law, if you simply appear before the Planning Commission or even just write a letter, you don't have to appeal in person. That gives you the standing to file an appeal with the Board of Appeals if you disagree with the decision of the Planning Commission. I think I covered everything on that page. If you go to the next page, other changes in Section 297-417 is that appeals will no longer be de novo. They'll be on the record appeals. And also the Board of Appeals, the standard for them as far as whether or not to reverse the decision of the Planning Commission is whether or not there's sufficient evidence in the record to support the decision of the Planning Commission. So basically, sufficient evidence is kind of the standard we're applying that the Board of Appeals will use to determine whether or not there was some error committed by the Planning Commission. And the appellant has the burden of going forward to show that there was an error that occurred, or in other words, there was not sufficient evidence to support their decision. Okay, I'm on section slide 9 now. This is an overview of the activities before the Planning Commission. The Planning Commission held a public hearing on February 13th, 2017. There was a follow-up meeting on February 27th, 2017, and at that time I submitted provisions to the amendments that were initially submitted, and those revisions are reflected in what is now 297-417, and specifically on who can file an appeal. And there was a work session held on May 22nd, 2017. And the final page, which is page 10, basically just summarizes the Planning Commission's recommendations. And essentially, the Planning Commission recommended that the Board of County Commissioners adopt the legislation with the change that includes the language from Section 4306E1 of the Land Use Article for the Maryland Annotated Code. And basically, that sets forth things like that the Board needs to have an appeal at a reasonable time, give public notice, give notice to the parties in interest, and decide appeal within a reasonable time. So in addition to the legislation that was given to them, they wanted this language from the land use article added in the county code legislation. And the Planning Commission also recommended that the Board of Appeals include in its rules of procedure the definition of who was an aggrieved person or aggrieved party. And that concludes my presentation.
Thank you very much. All right.
Thank you. We'll begin